welcome to Cornerstone Barristers webinar on renting homes Wales, called Big Issues and Appeal Points. So hopefully we will highlight some interesting parts of the Act this morning for you to think about and ponder on. My name is Sarah Salmon. I'm a barrister here at Cornerstone practicing in housing, property and public law. I have a special interest in Wales myself, alongside Alistair, who I'm joined with today. For the last few years have been drafting occupation contracts as part of Renting Homes Wales for a variety of clients. And I'm also the chair of the Social Housing Law Association Wales branch. And we're relatively new to Wales and trying to put on events over there. As I've said, I'm joined by Alistair Cantor. He too is a barrister at Cornerstone, and he specialises in commercial, regulatory, property and housing law. And as I said, has been involved in a lot of work in relation to Renting Homes Wales. I am going to begin today's talk. Can I please ask those with any questions to pop them in the Q&A box? We did have a question over email just before the webinar began. Alistair, I think, is going to answer that in the Q&A box. So let me just check. So Andrew Fenton, if you are on, Alistair is going to answer your question in the Q&A box. And just before we start as well, I want to highlight that we have our housing day coming up. It's on the 14th of October, and details are going to be sent round when the slides are sent round after, and the recording after the webinar. So what are we covering today? I'm sure most people on this webinar will be well aware of the provisions of Renting Homes Wales, but I'm just going to give a very brief overview of those this morning. I'm then going to discuss a couple of matters that interest me, which I've called matters outside the contract, particularly issues around consent and succession provisions. And then I'm also going to deal with the word incompatible and incompatibility, and just raise an issue there. Alistair is then going to take you through some slightly more technical points, if I can put it that way, about the conversion of existing types of tenancies, mobility clauses and sanctions. I'm also moving the slides, so bear with me. So I can't quite believe it, but it was over 20 years ago now when, in November 2003, the Law Commission wrote its first Renting Homes paper and suggested this wholesale change to tenancies across both England and Wales initially. Once England decided not to adopt it, it was 2013 when we saw the Law Commission write the Renting Homes in Wales paper. And following that, on the 18th of January 2016, we had the Renting Homes Wales Act 2016. That's when it received royal assent. It was originally announced in January 2022 that it was going to come into force and be implemented on the 15th of July of 2022. And you'll all be aware that that was delayed until the 1st of December. So we are nearly 2 years on from renting homes. And before I move on, given the title of this webinar, it might be remiss of me not to mention that the Divisional Court of the High Court has heard its first case in relation to Renting Homes Wales. That happened in July. I was part of the council team for the landlords, along with Jack Barber from Cornerstone, led by Justin Bates KC and Paul Bowen KC, and Ranjit Bose KC and Tara O'Leary, both of Cornerstone Housing, acted on behalf of the contract holders, and the Welsh ministers intervened in that case. We don't have judgment yet, but it's something to keep an eye on, and I can't say too much more about it at this stage. So in brief, what did Renting Homes do? So it created two types of landlord under the Act. It created community landlords, which are your local authorities and your RSLs or social landlords, and you have private landlords, which essentially are those who are not community landlords. It then created two types of contract: a secure occupation contract and a standard occupation contract. Now, there are differing versions of these contracts, in particular the standard. It can be fixed or periodic. For the most part, community landlords will use secure contracts, but there are certain types of contracts which will be standard, periodics, or even potentially fixed. And private landlords can opt to grant secure occupation contracts, but it is more likely that they would use standard contracts. There are also a number of arrangements that are excluded from occupation contracts, for example, shared ownership leases, holiday lets, accommodation shared with the landlord, and there's various other exclusions. What the Act also did is it dictated the terms or the types of terms that you have in an occupation contract. So you have the key terms. They are set out in sections 26 and 27 of the Act. There are key terms for secure, and then there are extended key terms for standard contracts. They include things like the rent, the rental period, and the date on which a contract holder can move into the property. You then have what are termed fundamental provisions within the Act. And what happens is these fundamental provisions must go into your occupation contract. Some cannot be modified at all, say for editorial changes. Some fundamental provisions can be modified where the landlord and the contract holder agree, but they can only be modified if that is going to be of benefit to the contract holder. Now, once fundamental provisions are incorporated into a contract, they become known as fundamental terms. You also have supplementary provisions within the Act, and once they are incorporated, they become supplementary terms. They are set out in regulations that have been made by the Welsh ministers, and they too are automatically included into occupation contracts. I'm going to come to some issues on conversion a bit later in this talk, but a landlord and a contract holder can agree to leave out supplemental provisions or modified, and they can be modified for the benefit of either party. What cannot happen with supplementary provisions, supplementary terms, is they cannot be omitted or modified if to do so would make them incompatible with a fundamental term. And I've stressed the word incompatible because you'll know from the brief overview of what we're going to cover that that is something I'm going to discuss later in this webinar. We then have additional terms. Now, these are terms which the contract holder and the landlord agree on. The Welsh Government guidance suggests that it will include terms as to the keeping of pets, for example. And I've put in brackets there existing because on the conversion process, all of your additional terms are likely to have been those terms which remain following the conversion process, which were in the original tenancy or license, which has been converted under the 2016 Act. So moving on to some matters that interest me and us as a team as we were drafting contracts and have since been advising on Renting Homes Wales. And the first set of interesting provisions are matters which I've said are outside the contract. And the first of those is consent. And you'll see that that is dealt with by sections 84 to 86 of the Act. And I think the reason why consent is quite interesting and is something, in my view, that is going to find its way before the courts is because the scheme has set out a process for a landlord giving consent for a contract holder to do something where there is a term in the contract that requires consent. So, for example, you can keep a pet, but with our consent, with the landlord's consent. And because it's set out rather rigidly, there are potentially some unintended consequences if landlords do not get it right. But also the Act has allowed for applications to be made to the court where consent is either refused or it is granted subject to conditions and the contract holder wishes to challenge those conditions. So it does strike me that this is something that is likely to find its way before the court. And the other thing which I've highlighted on the third bullet point there on the slide is why I think it's even more interesting is because it's not limited to where consent is required by the Act. So if a fundamental provision or a supplemental provision that's become a term of the contract requires consent, it is not just limited to that. It is limited to any additional terms where the landlord has said that someone requires consent. And I know during the conversion process, a lot of tenancy agreements contained terms which require consent to do something on behalf of, on the part of the contract holder that were carried over on the conversion process. So it attaches to all of those terms, which is why landlords need to be very clear as to what is required. So Section 84, in essence, says that a contract holder to obtain consent has to make a written request. So it must be in writing. So it'd be good for landlords to set up an email address or a post box or whatever it might be, so these requests can be made in writing. When a request is made, in order to deal with it, a landlord can ask for further information, but that has to be done within 14 days, starting from the day in which the request is made. So if as a landlord, you want further information, then you have 14 days to request that. If the information that's requested is deemed to be unreasonable in any way, then it's treated as that request never being made. So you have to be careful that the time periods may still run, even if you think as a landlord your request is reasonable. And this is where it gets tricky, because if you as a landlord do not give or refuse consent within what's called the relevant period, you are treated as a landlord as having consented without any conditions attached to that consent. And the relevant period is a period of 1 month, either starting from the date on which the request for consent is made, or if you ask for further information and that information is deemed reasonable, the day on which that information is provided. So they are short periods of time. Now, you might be sat there thinking, well, we don't get a lot of requests for consent, and that may well be the situation. But it is a short period of time for which landlords need to ensure they have systems in place to record and make decisions on these requests. So, for example, if you've got someone asking to keep a dog, you may well want further information because it may be a dangerous dog, and you may want to check that it's got the right licenses, it's kept the right way, and so on and so forth. But you only have 14 days to deal with that, and then a month to make any decision. There is a provision in section 86(1) that allows for consent to be given after the event. So if something has happened, you can give consent. You'll see on the slide there that doesn't apply to certain matters. And then you have Schedule 6, which all landlords will need to ensure they look through whenever they're dealing with any of these requests, because that applies to a determination of whether or not a landlord has reasonably refused consent, or whether any conditions imposed to that consent are reasonable. And it is split into 2 parts, as set out in the slide. Part 2 sets out the circumstances which must be taken into account for that purpose to the extent that they are relevant. and part 3 deals with specific kinds of transactions. Now, in all of my slides, which you will get a copy of, I've set out the law in some detail, but the purpose of this webinar is not for me to sit and read the law out to you. It's just to highlight some of the issues that the Act might flag up. So you'll see over the next few slides the types of things that have to be considered when you're looking at whether or not consent is given, or whether or not any consent needs to be subject to any conditions. And the final slide on this sets out the matters that can be challenged by the court. So if consent is refused or granted subject to conditions, you can see there that the contract holder, I'm assuming it's the contract holder, it might be someone else asking for permission, but they can request for the court to look at it, and they can say that there's been an unreasonable refusal or unreasonable conditions, and the court can make a declaration that it sees fit. The court may also, you'll see, declare whether the landlord has consented without conditions, or it can order the landlord to reconsider, and you can see the timeline as to the process there. And it can also make any other order that it thinks fit. Now, the reason I think this is interesting is not only because landlords will have to come to clear decisions and have records of those decisions in order to defend their position before the court that it wasn't unreasonable to refuse consent. But it's also because generally, as we know in housing law, the courts will defer more often than not to the local authority or the social landlord with regards to housing management and the housing management of their stock. And it seems to me this is quite a novel remedy for the tenant, which the courts are going to be getting involved with. And the courts could make decisions which impact on the management of social housing stock. For example, if someone wants permission to make an alteration and you've refused it, but the court finds that that was an unreasonable refusal. So you could find your stock changing and developing over time due to declarations made by the court when people seek consent. The second matter, which I've said is outside the contract, is the issue of succession. So again, the slide set out the new statutory framework for succession, and I'm not going to sit and read that out. But the one issue that we find interesting, and this is why I've put a question mark on that first bullet point as to whether it is actually outside the contract, is that when we were converting contracts, many contracts had their own succession provisions in them. And the question was, what happened on conversion? Well, those that drafted the 2016 Act did not make succession a fundamental provision. It didn't make it a supplementary provision either, but it didn't make it a fundamental provision. And on conversion, fundamental provisions all went in. And it was after that process that you had to then consider what happened with existing terms of the previous tenancy and supplementary provisions that would go into the contract. And existing terms of the tenancy or the license, whatever was being converted, would only be ousted if they were incompatible with fundamental terms. Because succession isn't a fundamental term, any succession terms within the original contract couldn't, in my view, be said to be incompatible. Now, there were some easier contracts on conversion, and those were the contracts that specifically limited themselves to the previous statutory regimes on succession under the Housing Act 1985 and the Housing Act 1988, because where those acts were specifically referenced as part of the contract, as part of the conversion process, where previous law had been repealed and no longer applied in Wales, then those sorts of terms would come out of the contracts. That was easy. But it was where the succession rights went beyond that or didn't mention the Act at all, And for the most part, I think the conclusion was that they had to remain in the contract. So it'll be interesting to see how and if this develops through the courts. We obviously had a relatively recent Court of Appeal case, the Clarion Housing Association and Carter, which dealt with how terms of the tenancy can lead to a succession. In that case, the tenant that passed away was a secure tenant of a local authority. As there was stock transfers, she became an assured tenant over time with Clarion, and she passed away, and Miss Carter set out reasons to Clarion as to why she should succeed, and she said it's the terms and conditions of the tenancy. And on appeal to the Court of Appeal, Miss Carter cross-appealed and said that she'd acquired rights enforceable against Clarion because she was the beneficiary of the trust of the promise made to Monica Carter, who was the original tenant, in order to observe the terms of the tenancy agreement relating to succession and what happened after her death. And that cross-appeal succeeded, and the Court of Appeal held that the terms of the tenancy agreement governing succession, although they were entered into by Monica Carter, they had the intention of conferring a benefit onto a third party, because at the end of the day, the tenant who had died wouldn't have any benefit from them. They would be of no use to her. So there was an intention in that case to create a trust, since there was also a potential class of beneficiaries as well. So it's going to be quite interesting to see how the Act works alongside terms and conditions of tenancy on succession, which have moved over due to the conversion process. That's another issue that we found quite tricky when we were converting contracts, and think might end up before the courts in due course. The final matter that I deal with this morning before handing over to Alistair is this idea of a term being incompatible or incompatibility with other terms. Now, I've realised since I drafted these slides that I've said it's a key term in the Act. I don't mean that. It's not a key term of the Act under sections 26 or 27 of the Act. What I mean is it is a phrase or a word that is used in the Act, and importantly, in my view, appears in two particular places. The first is you find it in section 24, and I think it also moves over into sections 107 and 108, where a supplementary provision, and I discussed this earlier, can be excluded or modified or varied unless to do so would make it incompatible with a fundamental term. So if a supplementary provision is being left out, whether it's a new contract or a converted contract, landlords need to think about, does leaving it out or modifying it in any way make it incompatible with any of the fundamental terms that have gone into the contract? The other place it appears in is section 240. And for those of you who were caught up in converting contracts, section 240 alongside schedule 12 were the main provisions upon which conversion occurred. And it's relevant in two places. First, any existing term of a tenancy or license that was being converted no longer had effect to the extent that they were incompatible with a fundamental provision that has been incorporated as a term to the contract. And secondly, supplementary provisions were automatically incorporated into converted contracts, except to the extent that they were incompatible with any existing terms. So for the conversion of contracts, you had a situation where you were putting in the fundamental provisions, and then the existing terms went in, save to the extent that they're incompatible with any fundamental provisions. And then the supplementary terms all went in, save except to the extent that they were incompatible with the existing terms. And the question is, what is meant by incompatibility? It's not defined in the Act. And I think this was a particular area that was extremely complex when we as a team were converting contracts, and a complex area for clients to make decisions on. We took the view, and I'm not suggesting for a moment it's right, that incompatibility meant being inconsistent, contradictory, or in conflict with a fundamental provision or an existing term, dependent on which part of the conversion process you're dealing with. That made most sense to us. And also the explanatory notes, I think, refer to something being in conflict with a term. But we did flag it as an issue that would need some certainty from the courts, because it also appeared to us that there could have been other ways of dealing with it. So you could take a high level view where if something was in conflict, it just came out, or should you have been amending those terms, taking a sort of subtler approach so that they were no longer incompatible? And I asked that question because it says save to the extent that. So a term could be compatible, save for the extent that the last three words of the term make it incompatible. So do you just remove the last three words, or do you take it all out? And clients were given the choice as to what to do. But I do think that ultimately this might be an issue that comes before the court in the future. And I know it was canvassed ever so slightly in the current litigation, although it wasn't the focus of it. So I don't know how far the current litigation will go in answering the question, but it's definitely something to look out for that might come up in the future. So I'm going to hand over to Alistair now, who's going to deal with the other topics.
Thank you, Sarah, and good morning, everyone. Very pleased to be speaking to you today about the Renting Homes Wales Act. And I am going to talk to you about 4 discrete topics over the course of the remainder of this webinar, and hopefully leaving a bit of time at the end for any questions that remain. So the first thing I want to talk to you about, as Sarah has already touched upon in terms of incompatibility, is converted contracts. And by that, I mean what happened to residential tenancies in Wales on the 1st of December 2022. The Act actually had a quite radical effect in terms of laws, whereby it extensively rewrote the terms and conditions of pretty much every single residential tenancy in Wales. And it did that. There were sort of 4 parts to that process, which I've set out on this slide. The first part was the Act, section 239 of it to be specific, abolished all the comfy old sorts of statutory tenancies that we had by then grown to know and love. The next step was it then converted those tenancies to occupation contracts. Section 240 of the Act kicked in, and what that actually says is that any tenancy existing on the 1st of December 2022 was to be treated as having been made as an occupation contract on that date. So effectively, they converted from the old tenancies into occupation contracts. Now, the next step was to work out what the terms and conditions of those new occupation contracts were. And that was where you had section 240, subsections 4 to 7, and schedule 12 to the Act, which effectively rewrote the terms and conditions of all these tenancies and now occupation contracts. And we'll be diving into that a little deeper over the next few slides. The fourth part of the process was, having rewritten the terms and conditions of all these occupation contracts / tenancies, the Act obliged all landlords under these converted contracts to serve written statements within 6 months of the implementation date. So effectively by the end of May 2023. Could we have the next slide, please, Sarah? So this really was the tricky part of all that, working out the terms of these converted contracts. And there was a formula of sorts set out in the Act at subsections 4 to 7 of Section 240. And the way it worked was this. First of all, you had to incorporate all the sorts of fundamental terms that went into that sort of occupation contract. I should have mentioned, of course, that depending on the type of statutory tenancy that preceded the implementation date, it would turn into a particular sort of occupation contract. So, just in broad terms, for example, a secure tenancy would turn into a secure occupation contract. An assured short hold tenancy would turn into a standard occupation contract, and so forth. So step one was you looked up the sorts of fundamental terms that applied to that particular sort of occupation contract. Those went in. The next step was you compared the terms that were already in there. So what you would call existing terms, or using the Act's terminology, additional terms. So you would then match those up against the fundamental terms. And if they were incompatible, that existing or additional term would be knocked out. But otherwise, everything that was already in that tenancy agreement went in. And then the third step was that supplementary terms under the Act would then be compared against the existing terms. And if any of those supplementary terms were incompatible with the existing terms, they would not be included, but otherwise they would all go in. So in terms of converted contracts, you almost had a hierarchy of sorts of terms. Top came fundamental terms, second came existing terms, and last came supplementary terms. But they would all go in provided they weren't incompatible with the next level up of terms. And that was also subject to a number of quite special rules and quite technical provisions that were all set out in Schedule 12, which created a variety of exceptions and modifications to be made to these terms, depending on the type of contract and the context. So to take a simple example from Schedule 12, you would have the obligation to reside in the dwelling as the only principal or home would be added to pretty much all sorts of converted contracts. Because the position under the Act is that there is no standard term, there is no mandatory term for contract holders to reside in dwellings as their only or principal home. Obviously, that's a sharp distinction with the previous position, whereas it would always be a term of a statutory tenancy that they do so. And so Schedule 12 says any converted contract has that term in it. To take a more complicated example, Schedule 12 makes some quite complicated amendments to the fundamental terms governing restrictions on a landlord's ability to serve a landlord's notice, sort of a Section 21 equivalent, to end contracts on a no-fault basis. So that sort of breaches of deposit legislation, gas safety checks, all those sorts of things. And Schedule 12 sort of makes some quite technical amendments to those terms. Now you'll notice an image on this screen. Sorry, Sarah, before we move on, there's an image on this screen. You might be wondering what that represents. Well, I'll tell you what I had in mind by it. The maze represents Schedule 12, and these people going through it are trying to work out what it means, which leads us neatly onto our next slide, where I talk about some tricky issues. And what I've just talked about, Schedule 12, relates to the middle one, which is complexity. Now, these rules were not easy. Schedule 12 in particular, I found quite difficult to navigate. And I'm a professional barrister with many years' experience working with housing legislation. And I found it quite difficult to work out what it meant in places and how to implement some of the changes to terms it required. And so, in my view, it will probably have created a number of bear traps for the unwary and even the legally trained in some cases. Linked to that is the issue on the left, which is incompatibility, which you might say is a sort of another aspect of complexity in terms of converting these contracts. As Sarah's already discussed, it was often not easy to tell first of all, not necessarily easy to work out what incompatible means, um, even for the legally trained at a macro and a micro level, as you were examining individual terms. And unlike new contracts, you don't have the option to simply leave something out because you're unclear. It's either got to be in or out. So if you're faced with a bit of a 50-50 call on whether something's incompatible, you had to either leave it out or put it in, and you could be wrong either way. But you've got no opportunity to avoid that dilemma by simply leaving it out. And the last tricky issue I felt arose when converting contracts related to fixed terms. So when you're converting statutory tenancies that had a fixed term prior to the implementation date, which will lead us neatly onto our next slide, where I explain why that's a tricky issue. So where you were dealing with a fixed term statutory tenancy, so for example, an assured short hold tenancy for a 12-year period, let's just take that as an example. When you came to convert a contract like that, you basically sort of had three scenarios that might apply. The first is that by implementation date on the 1st of December 2022, the fixed term would have expired already. Now, in that situation, you have quite an easy job. What happened when the fixed term expired is that a periodic standard assured short hold tenancy came into existence. And that's quite an easy task for you, subject to the other issues that we've discussed. You simply have to prepare and serve a periodic standard occupation contract written statement and serve it on your contract holder. The second scenario is trickier. So what happens if the fixed term expired after the 1st of December 2022, but before the 31st of May 23? And if you were savvy, you would have waited for that fixed term to expire before you do your written statement. For this reason, if your fixed term expired after implementation date, let's just say a hypothetical date of the 1st of February 2023, what would happen is that on implementation date, probably if you had a fixed term AST, it would have converted into a fixed term standard occupation contract. But then on the 1st of February 2023, so you have then a fixed term occupation contract in place, but on the 1st of February 2023, the contract holder remains in occupation. And what happens is you get, I call them a statutory periodic occupation contract under section 184 of the Act, which says basically, it's equivalent. You roll on, you have a statutory periodic tenancy. And so when that happens, when you have a periodic statutory occupation contract, you also have to serve a written statement. So in that scenario, you would not serve a fixed term, a written statement for a fixed term occupation contract. You would have to do one for a periodic standard occupation contract. But because it is one arising under section 184, it actually has some slight differences in the terms. So you would have to make sure you served a type of written statement for periodic occupation contracts that has been tailored to that particular scenario. The third scenario is, as I've outlined on the right-hand side, this is where the fixed term was not going to expire by the 31st of May 2023. Let's say you had a 1-year fixed term AST running from the 1st of November 2022. You've only got till the following May to do a written statement, so you're going to have to serve one. And that written statement would have to be probably a fixed term occupation contract, standard occupation contract. But what will then happen is whenever that 1-year period expires, you are going to have to serve another written statement reflecting the periodic standard occupation contract that arises under Section 184. Now, most savvy landlords deal with that by using the provisions of Section 185 of the Act, which says if you ever serve a written statement for a fixed term standard occupation contract, you can address what the terms of the periodic standard occupation contract that will follow in that written statement. And usually the way I think is best to do that is you append to the written statement for the fixed term occupation contract a further periodic standard occupation contract, and you say when the fixed term expires, these will be the terms of the periodic occupation contract that will follow, and that way you comply with both obligations in terms of serving written statements. Now, why does all that matter? In my view, there are many landlords who are likely to have got some of this wrong. It is very complicated. That opens them up to claims for compensation. Those claims for compensation can be set off against rent arrears, and then you have cost implications because claims like this are going to be going on the fast track through the county court, and costs will follow the event. And that will be serious enough for individual landlords, but also you must bear in mind that there are some very large-scale landlords in the sector where if there's an issue with one contract, it will be replicated across several. So I think it's a technical area. It's not easy to get right, and so we'll probably see some cases eventually starting to filter through the court about some of these points. I now want to talk to you about another sort of conversion, or at least it's something that I've dubbed conversion, which is what happens to supported and homelessness accommodation occupation contracts at a certain point. And I'll explain exactly what I mean by all this if we go to the next slide. So as I've put on the left here, the context is in the case of supported accommodation, a tenancy or license under the Act will not be an occupation contract within the first 6 months. And there is then a process in the supported accommodation context for that initial 6-month period to be extended, subject to challenges by the occupier and so forth. But a supported accommodation tenancy or license for the first 6 months of its life, it will fall without the scope of the Act. You have a very similar situation in the context of homelessness accommodation. Homelessness accommodation will be outside the Act in 2 scenarios. The first is where the tenancy or license is made with a local housing authority, and that local housing authority is not yet satisfied it owes the full housing duty under Section 75(1) of the Housing Wales Act 2014. So it's short of the main housing duty. The second is where arrangements have been made with a landlord other than a local housing authority to provide accommodation under homelessness requirements on the part of local authorities. And such a tenancy or license will not be an occupation contract for the first 12 months, or what the Act calls the notification period. What problem does that create? What you will have then is where you have supported accommodation and homelessness standard occupation contracts, they will almost invariably have been preceded by some form of common law tenancy, or more typically a license. So at some point, those tenancies and license turn into occupation contracts. They do not end, they become occupation contracts. And there is no conversion mechanism in the Act as to what happens to the existing terms of these tenancies and licenses. And you contrast that with something we've already discussed, which is Section 240 of the Act, which sets out a detailed formula for exactly how you work out the terms of converting the old statutory tenancies into the new occupation contracts. And there is no such mechanism in the Act for these particular sorts of tenancies and licenses. So what's the effect of that? You have to sort of go to first principles and look at all the terms of the Act, but my take on it is the fundamental terms are obviously incorporated at the 6th or 12-month point. The supplementary terms will be incorporated at the same point because there wouldn't have been an agreement between the landlord and the contract holder to exclude them. So there you go. You sort of insert the fundamental terms and the supplementary terms. What happens to the existing terms? Well, they must become additional terms, which is what the Act says is any term that isn't a fundamental, a supplementary term, or a key matter. And then you have to bear in mind the effect of Section 28 of the Act. That's the follow-on effect, which is that any additional term that is incompatible with a fundamental or supplementary term will be of no effect. And as a result of that, it shouldn't even be included in the written statement, because then it would be an incorrect written statement within the meaning of Section 37 of the Act. So effectively, it's like the conversion process, but slightly different. You have the fundamental terms and the supplementary terms go in, and then any existing terms that aren't incompatible will go in, but any that are incompatible get knocked out. So why does this matter? I mean, again, you're going to have the same issue if landlords haven't got this right. You're going to have claims for compensation. It's going to present practical difficulties because landlords often want to exclude at least some of the supplementary terms as they're entitled to do by agreement. So, for example, in the supported accommodation context, often landlords aren't keen on including the supplementary term that entitles the contract holder to change the locks of their property. So if you have something in a license that says you can't change the locks, and then it just turns into an occupation contract, probably what would happen is that existing term would be knocked out and the landlord would be stuck with the supplementary term that permitted the occupier to change the locks. And as a result of that, I believe what's happening with many landlords is they tend to conduct some form of sign-up exercise towards the end of that first 6 or 12-month period where they go, right, this is now going to be an occupation contract. We need you to sign an occupation contract agreement. So we're now going to move on to the next topic, which is mobility clauses. And we should be able to cover this fairly quickly. A unique aspect of supported accommodation occupation contracts is that the Act provides a discretion, or at least permits the landlord to agree with the occupier that they are going to be moved between different rooms. So it's often the case in supported accommodation, there might be some need for the residents to be moved, most typically in between different rooms in the same building. And you can see there, Section 144, which I've set out on the left-hand side of this slide, makes provision for this. It says that a supported standard contract may provide, it doesn't have to, it's not a fundamental term, but it may provide that the dwelling subject to the contract is the dwelling within a building specified in the contract, as is from time to time specified by the landlord. So that means if you get a term in the written statement that allows you to do that, the landlord could say, right, you've got to move between rooms, and all the terms and conditions will apply to the particular room that you reside in from time to time. The question I think that's cropped up arises because in some cases, social landlords running supported accommodation projects will have several buildings within the same scheme. So there may be a requirement not only to move residents between different rooms of the same building, but between rooms in different buildings. And the question is whether or not Section 144 can be read to allow that, or whether it should be restricted to rooms within the same building. Because obviously, as I've just read out to you, Section 144 says a supported standard may provide the dwelling subject to the contract is the dwelling within a building, singular. So the question that arises there is it just one building? Can it be more? And I think there's arguments to go both ways, because on the one hand, it says it may be a dwelling within a building specified in the contract. You could say, as long as the building is specified in the contract, i.e. it can be more than one, you can have residents moving between different rooms. The countervailing argument is that, well, it says a building, that's singular, it must only be one. So the landlord's flexibility only extends as far as moving people between rooms of the same building. And of course, what would then arise from that potentially in some cases is, how do you define a building? What are the limits of a building? It could just be the same structure, or what happens if there are sort of annexes or outbuildings? Should that fall within the definition? So this is another issue that may it's quite a niche issue. It's specialised to supported accommodation, but it is something we might see form the basis of an appeal or a case at some point in the near future. Next slide, please, Sarah. The final topic I wanted to talk to you about is the subject of sanctions. And if we could go to the next slide, please, Sarah. I've already touched upon the fact that under the Act, if landlords haven't done what they need to in terms of written statements, they can be subject to legal action on the part of their contract holders. And set out on this slide are the various obligations that apply in terms of the provision of written statements and the ways a landlord can fall foul of them. The chief one in the main circle in the centre is a failure to provide any written statement at all. So if the landlord simply doesn't provide a written statement, they're in breach. They will also be in breach if they serve one that is incomplete, so it doesn't include all the terms it needs to, or one that is incorrect. So this might have an error in the way it phrases a fundamental or supplementary term, or it might have some sort of problem in the way it cross-references between terms. Other obligations that apply and that may be breached are, in the top right, you have a circle marked information re landlord. That is the obligation under Section 39 of the Act, which is to provide the contract holder with an address at which documents may be served on the landlord. You also have the obligation to serve, whenever a term is varied, the landlord has to serve notice of the variation on the tenant. And these sections of the Act, so you have sections 34 to 36, section 39 I've already mentioned, section 110, 129 and 137, those all apply to variations. These sections, along with section 87 of the Act, give rise to potential rights on the part of the contract holder to obtain compensation from their landlord. Those go alongside remedies for declarations as to terms and other complementary remedies. Next slide, please. Now, the key issues that arise, I feel, for determination in the near future is firstly the question of intentionality. When you look at the powers of the court to award compensation to contract holders, whether or not the landlord's default has been intentional, to use the terms of the Act, is often core to any such claim. In some cases, compensation may not be awarded at all unless the landlord has acted intentionally. So if the landlord serves a written statement but it's incorrect or incomplete, the court can only award compensation if that default was intentional. Then more broadly, for example, if they other obligations, so the obligation to provide a written statement, if it's not complied with, the compensation is automatic. But if the landlord's default was intentional, the court has the power to up to double the compensation awarded. Um, but despite the importance of the concept of intentionality, there's no definition in the Act. Nowhere is it defined. Um, in the explanatory notes to the Act, it does refer to deliberate. It must be a deliberate act, but I don't think that really takes us much further. So really, what intentional actually means is in need of clarification from the courts, in my view. I mean, you can imagine it being easy in some cases to tell. So if a landlord simply doesn't bother to serve a written statement, then you'd probably be compelled to conclude that's intentional. But what about situations where they include a term which they reasonably believe is not incompatible in some way, or they've simply made a mistake? Is that intentional? Now, what if the answer to that is no, but let's say a court decision comes out ruling on a very similar term, and it holds that those sorts of terms are incompatible? What are the obligations on a landlord there? Do they have to um, serve their tenants with correct written statements saying the court's ruled on this, it's not appropriate to include? What about typos? The Act requires landlords to cross-reference between all the different terms in the contracts. That's very complicated and painstaking. I think it's almost invariable. There'll be lots of mistakes that have been made there, often completely good-natured and unintentional ones. Is that intentional? And what about if it's not intentional? What about where a landlord discovers that they have made a typo? Are they obliged to send notice of a correction to all their tenants in order to escape claims for compensation? These are all the sorts of questions and scenarios that courts may have to look at and rule upon in the near future. And the second key issue around sanctions, which I'll just very briefly cover, is one of quantum. As I've already discussed, there's a discretionary aspect to compensation. Generally, the court can award up to 2 months, and they can sort of up to double it if there's been an intentional default on the part of the landlord. So up to 4 months rent. But it's discretionary. So what's the approach of the court going to be to how much compensation that's awarded? I mean, one can probably anticipate some assistance being derived from tenancy deposit claims and the case law surrounding those, where, for example, the scale of the landlord, the amount of resources available to them, whether the breach is sort of calculated, those sorts of things are going to impact probably on the amount of quantum, but it's all completely novel legislation. And so that's another thing I suspect the courts will be examining at some point in the not too distant future. I think that concludes everything that I wanted to talk to you about today. I don't know if there are any questions that remain unanswered or in the Q&A. It looks like we've answered all of them. There's one open question that I think Sarah is in the process of answering. So if anyone does have any questions, now's your moment to type them up in the Q&A box. And if you're too shy or something later occurs to you that you wish you'd asked and you missed the opportunity, then please do feel free to get in touch with us via Chambers. And we're usually happy to answer quick and short questions about particular issues under the Act.
I'm trying to answer one question, but another question has come up about do you have any idea when the judgment will be given on the divisional court case? I don't. Obviously, there was a break over the summer. I imagine it will be relatively soon. It may not be handed down particularly soon. I'd like to think in the next month, but we haven't been given an indication. Right, okay. I think I'm going to try and answer the questions and say goodbye to you all. Thank you for attending.